Welcome back to Security for Legal SaaS. I'm Alice.
And I'm Dan. Episode 61 Customer Trust and Security Reviews. Alice, last episode we talked about getting certifications. This episode is about what happens when a prospective client puts you under the microscope.
Right. And the microscope usually arrives as a spreadsheet. 4:47 on a Friday afternoon. 300 questions. Your answers determine whether you close the deal on Monday or lose it to a competitor who was ready.
Security questionnaires. I've heard these are a huge time sink for SaaS vendors.
They are. The average enterprise vendor receives hundreds of these per year, each with 50 to 400 questions covering encryption, access control, incident response, data handling, business continuity, every security domain we've discussed across this series. Across your entire sales pipeline, the cost in staff time and delayed deals is enormous. But they're not going away, because for the law firm on the other end, this is how they prove due diligence. If they buy a platform that gets breached and they never did a security review, that's negligent.
Right. So what are these questionnaires actually asking?
They map to the same topics we've covered for 60 episodes. Do you encrypt data at rest and in transit? Episode 13. How do you handle authentication? Episodes 17 through 22. What's your incident response process? Episodes 52 through 56. Where is data stored geographically? Do you have a SOC 2 Type 2 report? Do you have a recent penetration test? Who are your sub-processors? Meaning, which third parties touch customer data? Do you have a data processing agreement ready to sign?
That's a lot of ground. Is there a shortcut?
The best shortcut is having a SOC 2 Type 2 report. When a procurement team asks, do you have SOC 2 Type 2, and you say yes and attach the report, it eliminates dozens of follow-up questions. The auditor has already verified your controls across security, availability, and confidentiality. That doesn't mean the questionnaire goes away entirely, but it dramatically reduces the back and forth.
What about a trust center? I keep hearing that term.
A trust center is a dedicated page, public or gated, that centralizes all your security documentation in one place. Your SOC 2 report summary, your ISO 27001 certificate if you have one, a penetration test summary, your data processing agreement as a downloadable template, a list of your sub-processors, an architecture overview showing your infrastructure and encryption approach, and your privacy policy. Research shows that vendors with trust centers close deals roughly twice as fast, because prospects can self-serve answers to common questions before the formal review even starts.
Yeah. So you're front-loading the information instead of drip-feeding it through email chains.
Exactly. And here's a tip specific to legal SaaS that most trust center templates miss. Include a section on legal professional privilege. Explain how your platform handles matter-level access controls, privilege classification, and litigation holds. A law firm's procurement team will look for this, and generic SaaS trust centers never cover it. This is where you differentiate from platforms that happen to sell to law firms versus platforms built for law firms.
That makes sense. Now, DPA negotiation. We covered the basics in episode 59. What does it look like in practice when a client actually wants to negotiate one?
Most of the DPA is standard. It covers the Article 28 requirements. Where negotiations get intense is around 5 specific clauses. First, breach notification timelines. GDPR says, without undue delay, but your client will want a concrete number. 24 hours from discovery is increasingly the standard for platforms handling privileged legal data. Second, sub-processor consent. Some firms want specific approval before you engage any new vendor. Third, audit rights. The client technically has the right to audit you, but you can negotiate practical terms. Reasonable notice, cost sharing, and the option to substitute your SOC2 report for an on-site visit. Fourth, data deletion on termination. Exactly what happens to their data when the contract ends, including deletion timelines and a certificate of destruction. And fifth, the commercially sensitive one. Liability caps for data protection breaches.
Right, the liability question is always the hardest.
It is. Some DPAs try to uncap liability for data breaches entirely. You need to understand your insurance coverage and negotiate a cap that's defensible but doesn't expose you to existential risk. This is one area where having a lawyer on your own side of the table, not just the client's side, matters enormously.
What about the breach notification clauses in the main contract, the MSA?
Beyond the DPA, your master service agreement will have its own breach notification provisions. What procurement teams want to see? A notification timeline of 24 to 72 hours from discovery, not from the completion of your investigation. The scope of what you'll report, nature of the breach, data affected, remedial measures. A commitment to ongoing updates until the incident is resolved. A root cause analysis delivered within 30 days, and a remediation plan documenting what you'll do to prevent recurrence.
Yeah, the key point there is from discovery, not from confirmation. The clock starts the moment you know something might be wrong.
Exactly. Clients have been burned by vendors who delayed notification for weeks while they investigated. The expectation now is early notification, even if the picture is incomplete, with progressive updates as you learn more.
One last thing. As the questionnaire volume grows, can you automate any of this?
You can and you should. Tools like Vanta, Drata, SecureFrame, and Hyperproof maintain a centralized knowledge base of your approved answers. When a new questionnaire arrives, the tool maps the questions to your existing answers, pre-fills what it can, and flags only the questions that need fresh input. This cuts response time from weeks to days and ensures consistency. The answer you give one firm about your encryption matches what you told every other firm.
Right. Consistency matters because these firms talk to each other.
They do, and conflicting answers between two questionnaires is a red flag that raises more questions than it answers.
Next episode is the series finale, episode 62, Security Roadmapping. 61 episodes of security knowledge, compressed into a practical plan of what to do first.
Until then, I'm Alice.
And I'm Dan.
Security for Legal SaaS is a series written with AI assistants. Alice and Dan are AI-generated voices. No professional advice here, just education.